Good day, ladies and gentlemen. Welcome to another episode of What If, where we bring you the latest insights and updates on the ever-evolving landscape of employment law. I'm VP Moolman from Maserumule Corporate Employment Law, and in today's episode we will unpack what if an employee is dismissed for operational reasons. When is severance pay not due? Now, as you are aware, an employee is entitled to severance pay in cases where his or her services were terminated based on the employer's operational requirements. But as we will discuss today, there are certain scenarios where an employee, even if they are retrenched, will not be entitled to severance pay. Section 41 of the Basic Conditions of Employment Act deals with severance pay, and it provides that an employer must pay an employee who is dismissed for reasons based on the employer's operational requirements severance pay equal to at least 1 week's remuneration for each completed year of continuous service with that employer. What is important to note is that Section 41, subsection 4, relieves an employer of the duty to pay severance pay in circumstances where the employee who is dismissed for operational requirements unreasonably refuses to accept the employer's offer of alternative employment with that employer or any other employer. Now, back in 2006, in the matter of Irvin and Johnson versus the CCMA and others, the Labour Appeal Court held that the purpose of severance pay in our law is not necessarily to tide the employee over while he is looking for another job. The court held that if that was the purpose, an employee who immediately walks into another and sometimes even better paying job after his dismissal would not be entitled to severance pay because he would have no need for it. The Labour Appeal Court further sketched different scenarios when severance pay is payable. These scenarios are: firstly, if an employee unreasonably refuses an offer of alternative employment, no severance pay is payable. Secondly, if the employee refuses or reasonably refuses such alternative employment, he or she is entitled to payment of severance pay. Thirdly, if the employee accepts the alternative employment, he or she will also forfeit the right to severance pay. And finally, if an offer of alternative employment is made to the employee, but the offer is not made by his or her employer or through the efforts of his or her employer, he or she would be entitled to severance pay even if the employee turns the offer down. Now, recently, and in the matter of Service Landscaping Turf Management versus Sakalu, the Labour Court revisited the application of Section 41, subsection 4 of the Basic Conditions of Employment Act. Now, in this case, 22 employees were not paid severance pay by Service as they took up an offer of alternative employment. Interestingly, the offer of alternative employment was with another employer, namely Bidvest Topturf. The employees referred a severance pay dispute to the CCMA, and the Commissioner found that the 22 employees were in fact entitled to severance pay when they were retrenched by Service. The crux of the arbitrator's award was that she decided that Service failed to prove that the employees obtained alternative employment with another employer on the basis of Service offering them employment with this other employer. She found that at best, Service did play a part in facilitating the employment of employees by Bidvest, but to suggest that it has secured the employment in the absence of an agreement between the parties in this regard is to take matters too far. Service, unhappy with the arbitration award, took the matter on review to the Labour Court. At the Labour Court, the court held that it is plainly evident from the correspondence between Service and Bidvest that there was a collaborative process underway between them in order for Bidvest to hold interviews and make offers of employment to the Service staff who were facing retrenchment. Service set the ball rolling by approaching Bidvest to take on staff it could not accommodate, and Service followed up on the progress that Bidvest was making in the recruitment of its staff, and Bidvest used Service facilities extensively in the recruitment process. The court also held that the process followed by Service cannot be equated with an employer who merely gives a staff member a good reference and advises them to approach the employer who is taking over a contract from it. Service kept a close eye on Bidvest's recruitment of staff, and it made its premises and facilities available to Bidvest to try and ensure that nobody would be left unemployed, and also ensure that the staff moving to Bidvest would not lose a day's work. The end result was that everyone who wanted to be employed by Bidvest was. The Labour Court therefore found that the Commissioner had made an error in law in terms of which she regarded anything less than a binding undertaking obtained by service from Bidvest as irrelevant to the determination of liability for severance pay. The court then concluded that the employees employed by service were not entitled to severance pay. So, ladies and gentlemen, in conclusion, if an employer can prove that they made a significant effort in securing alternative employment for their employee with another employer, which alternative employment was unreasonably refused by the employer may rely on Section 41, subsection 4, to exclude the employee from receiving severance pay. So that then brings us to the end of this week's episode. Thank you for joining us. We hope you found our discussion informative and valuable. If you have any questions or comments, we'd love to hear from you. You can find us on social media or email us at info@masconsulting.co.za. If you are interested in staying up to date with the latest news and insights on employment law, please be sure to subscribe to our YouTube channel. Thanks again for tuning in. We'll see you next time. Bye-bye.